Thanks for joining us today. I'm Chad Koulis, Executive Director of the Midway Chamber of Commerce, and we have a program today about paid family medical leave, a program that is beginning in the state of Minnesota, effective the beginning of 2026. And we are joined with Gina Lemon from Vivid Joy HR. And Gina, I'm going to have you take it away.
Great. Thank you, Chad, for having me here and for all of the employers on the call. We appreciate you being here. The law of Minnesota paid family medical leave is going to be effective January 1st, 2026. So our guidance is to start preparing now. We'll go through a quick agenda, basically a disclaimer, the introduction to Minnesota paid family medical leave, who's covered, the employers and the employees, the employee qualifications, employer and employee contributions, qualifying reasons that someone might take a leave, the covered family members, benefit details and payments, the question around intermittent leave and supplemental benefits, private plan
Perfect.
options,
We'll get it pulled
notice.
and then when we're ready.
Sorry, just give me one
Good
second. If
job,
everyone
right?
could mute your line, that would be great, just so that we don't get any feedback. Intermittent leave, and if someone's eligible to go out for intermittent leave, what the private plan options are that are available to you if you prefer to not partner with the state, taxation of the benefits, as well as what sort of support and resources are available. So a quick disclaimer, this presentation is for educational purposes only and is not to be used as legal advice. Legal advice does differ and usually is case by case due to the unique matter of each different business. So this is the sole opinion of myself, Gina Lemon with Vivid Joy HR. However, at the end of the presentation, I do partner with a small business attorney and I'll provide you her contact information if you would like some legal advice on this matter. So the introduction to Minnesota paid leave. Minnesota paid leave is set to begin on January 1st, 2026. It's a program that's run through DEED, and the program aims to provide paid leave benefits for all employees in Minnesota for qualifying reasons. And this does cover most employers with one or more employee, and that includes seasonal, part-time, temporary interns, anyone that makes over the state average weekly wage dollar amount, which we'll cover in this slides. So before we get grounded in paid family medical leave, I do want to go through a couple of slides to really set the stage for how complex the laws are becoming and the interconnectivity of state and federal leaves as well as paid family medical leave. So today, some of the state leaves that you might be required to provide to your employees include earned safe and sick time, the parental leave, pregnancy accommodations, nursing, mother and lactation breaks, school activity leave, a bone marrow leave, voting leave. These are just an example of some of the state leaves that are going to continue to be there. So I've received some questions about parental leave, pregnancy accommodations. Will those laws go away? The answer is no, that all of these leaves could correlate and be connected with paid family medical leave as well. I'm just going to get a drink of water really quick. Excuse me. So we also have federal required leaves. And the federal required leaves could be FMLA, depending on your employee count, USERA, jury duty, witness leave, or ADA leave. And depending on the amount of employees you have, they could be paid or unpaid leaves. So one of the challenges, give me one more second. So one of the challenges is that you could have state or federal leaves as well as paid family medical leave that all are stack or intercorrelate. So for example, I had one client recently where they had an employee out on work comp and work comp claim was denied. So then they had to go through the Americans with Disabilities Act to see if they needed to provide accommodations. And then they had short-term disability as well as FMLA because they were over 50 employees within a 75-mile radius. And now coming up in January, they might have paid family medical leave as well. So it's one employee in 5 laws, which is why I wanted to ground us in the fact that honestly, there could be more complications that are impacted for the small to mid-sized businesses. So with paid family medical leave, the covered employers are going to be any employer with one or more employee in the state of Minnesota, and it's going to include religious organizations, nonprofits, the state, municipality, and local governments. The two organizations that are exempt would be any federal government employees or those that are part of tribal nations. So again, covered employees is anyone that has worked 50% or more of their employment during the calendar quarter, and that work is performed in Minnesota. So those are going to be the employers and employees that are covered. The qualifications is anyone who's earned at least 5.3% of the state average annual wage. And you're going to see that come up in the slide deck as the SAW rate. And that's going to be basically their annual wages earned over a period of time, which is the past 4 quarters, because paid family medical leave will work on a 12-month rolling calendar period. Also, the base of 2024 figures, that SAW rate is about $3,900. So every quarter, you're going to see that number continue to fluctuate. However, that's the dollar amount that we're going off of today. And there is no duration of employment or hours worked required to become eligible. So one of the questions that I've received a lot is, when do we start deductions? If someone's on payroll and if we assume that they're going to make that annual figure of about $3,900, they're going to have the deductions starting right away as soon as they start employment with your organization or as of January 1st. So again, we'll go through some Q&As later about how that is impacting your particular organization. Also, we want to talk about the employee contributions. So because we have a different amount of employers, the size of your employees on this call, we are going to go through both of these. So contributions will start January 1st, 2026, and those are going to be payroll deductions. So you will need to connect with your payroll provider, whether that's ADP, Paychex, Gusto. If you're using QuickBooks on your own, it'll be something that you need to set up with your payroll provider. And the initial premium rate is set at 0.88% of payroll. And that's for anyone that has 31 or more employees. If you are a small employer, which is 30 or under, so that 30 number, you would still be considered a small employer. 31 is a large employer. That small employer will receive a discount. And the small employer for 30 or under will be 0.66. However, if you have a private plan, it could actually be less than 0.66. But employers can charge employees no more than 50% of the total PFML premium. And I want to just pause here for a quick second, because the 0.88% for the large employer and the 0.66% for the small employer, what will happen and how the discount for the small employer is actually determined is that the small employer of 30 or under, they can charge their employees still the 0.44% because we're leveraging it off of this initial 0.88%. So the small employer would have 0.44% that's charged out to the employee, and the 0.22% would be what the employer pays. Now, if that employer is on a private plan and they have, let's say, 0.6, then again, they could charge their employees 0.44%, and the employer could be charged 0.2 instead of the 0.22%. But that's where the small employer will receive that discount. They still can charge that employee the 0.44. And then the required premium contributions do need to be made to the state, and those contributions are going to be due the 1st of April, or that April timeframe of the 1st through the 30th. And then if you are on a private plan, typically those contributions would happen at a monthly rate. Again, employee contributions are going to be 50% of the required contributions deducted from their wages. So again, it's going to be the maximum of 0.44%. Employers must notify employees of payroll deductions before December 1st. As a follow-up to this, I can partner with the chamber to get you over that state documentation as well as employment posters that can be sent out with this slide deck. So that way you're all set and ready to go. There's a couple of blanks that you'd have to fill out on the documentation, but everyone does need to sign off on the communication to your employees, and it's going to need to be held in your personnel records that every employee has been notified and they sign off on that before December 1st, or as employees are hired after January. The contributions are going to be reflected on paychecks and earning statements beginning January 1st. So there are a couple of qualifying reasons for leave. You will have personal health conditions, and personal health conditions would be for a serious health condition. I tend to think about things that might not be seen, like irritable bowel syndrome, migraine headaches, nervous disorders that might not be seen. And then you have things that might be more apparent. Someone could have diabetes that they're managing. They could have kidney failure where they're on a transplant list. They could have cancer, some more potentially impactful, life-altering concerns for their own serious health condition, but both could technically be approved for a qualifying reason. Then you have family care. So maybe a family member has some of those serious health conditions and they need care for as well. Then you'll have bonding with a child. So that bonding could be for biological, adoption, or foster. You'll have military related concerns or someone that might need help from a safety leave perspective, whether it's sexual assault, stalking, domestic violence for themselves or a family member. So I want to pause here quickly too, because for qualifying reasons for leave for baby bonding, there is going to be an interesting double dipping process that could happen only for 2026. So if I was out on maternity leave for May, June, and July of 2025, and I took 12 weeks for maternity leave, maybe it's FMLA that I was able to leverage or a parental leave. Now for 2026, it's a new clock that's starting January 1st. So if I took 12 weeks for medical maternity leave in 2025, I have until the child turns 1, so May when the baby was born, to take baby bonding. So that could be an additional 12 weeks that I could take out for baby bonding, or my husband could take out for baby bonding. There will be some double dipping that happens in 2026. I just want to make sure everyone's aware of that as a potential. Also, for covered family members, there are specific reasons that you could go out to take care of covered family members, a child. And again, these terms are very broad. So the child could be an actual child, biological, adopted, or foster, stepchildren, children of a domestic partner, or a child who the employee stands in loco parentis. So they could be a legal guardian or de facto custodian, or someone that is considered that you're their parent. Same with a parent. It could be the biological, adoptive, foster parents, all the way down to someone who stood in loco parentis to an employee. So, for example, my father unfortunately passed away when I was 17, but I might have a father-like figure that has just been diagnosed with cancer, and now I need to help him with radiation or chemo appointments because he stood in place of my father. Now I can also seek to take time off to support him. So spouse, domestic partner, and then also extended family members. Again, this is a pretty broad definition where we have a personal relationship creating an expectation that the employee will care for them without compensation. And that could be broad enough to even include my next door neighbor. If they have relied on me for care and I'm not being paid by my next door neighbor, that person may qualify to take leave out of your organization. So a couple of details in regards to benefit details and payment. The maximum leave that would be provided would be 12 weeks for family leave and 12 weeks for medical leave, or a combination of 20 weeks. And it will be determined if someone from the state could take time out for their own serious health condition, as well as caring for someone with a serious health condition. But again, the combination of any of these leaves is up to only 20 weeks. The weekly benefit amount, again, is going to be based on that state average weekly wage. And the 2026 wage is yet to be determined, so this number will probably continue to go up. But the benefit amount that someone would be paid is that $1,423. And depending on the wages that they're making, those numbers are going to vary. So there is a calculator out on the state website, and I'll give one slide that just kind of gives you a brief understanding of what those dollars could look like. The other thing is there is a waiting period. So if someone does need to go out, they do need to elapse a 7-day qualifying period in order to receive payment out. So if I go out today, being Wednesday, November 12th, then I would need to wait until next Wednesday to actually receive payment for the previous 7 days. And again, all of this gets funneled through the state. You are not going to have to approve or deny a claim or pay out the claim because you're making those payroll deductions and all of the employees are making the payroll deductions. All of this gets funneled through the state. So the weekly benefit calculations, again, depending on the weekly wages someone receives, they could receive up to 90% of that portion. And again, it's going to be equal to 50% of that state average weekly wage. Plus, if they're a lower wage income earner, it could be 66% of the portion of their weekly wages. Or again, if I'm a high wage income earner, it could be 55% of their weekly wages. So the next slide will actually give you an example. And these were based off of the initial SAW. So you'll see that this number is a little bit lower. It was at 1372, and now we're up to 1400 and some change. So depending on the yearly wage, so I again start with a lower wage income earner, to up to a large weekly wage income earner, you're going to see the weekly wages that are provided and the potential for the weekly benefit amount and the wage percentages. So I just want to show you that the weekly benefit dollar amounts will change based on the income that someone has. Let's get into intermittent and supplemental benefits as well, because the question has been asked, do people need to take time out in certain amount of time periods? Would it be a full 12 weeks? Would it be a week at a time? And for intermittent leaves, for example, if someone has that serious health condition, they could take incremental leaves of not less than 1 calendar day. And it's also been determined that employers can actually determine that within their policies. Intermittent leave could happen an hour at a time, 4 hours at a time, or 1 calendar day at a time. And based on your policies and procedures, you can determine that. So if you have something, I'm thinking of over the road truck drivers and they need to be gone for the full day, it's really hard to only be gone for an hour or two. That company might say, you know what, intermittent leaves will approve. However, it needs to happen on daily increments and we're not going to go underneath a full day. So again, you can determine those policies for your organization. And again, it does need to be a serious health condition if it's reasonable and appropriate, and employees need to provide a schedule of work days off as soon as practicable. And then payment for intermittent leave can be claimed after accumulating 8 hours, but not less than that 30 days have passed since the first time of their leave. Employers can also designate paid supplemental benefits, or you might have supplemental benefits today, and the employees can choose to receive full salary continuation during their leave. Employers have discretion over offering supplemental benefits, and the decision to have supplemental benefits does not affect the employee's entitlement to paid benefit leave. So the Minnesota paid family medical leave would be first, and the supplemental benefits could go on top of that. But as an employer, you also cannot mandate that they take paid time off, earned safe and sick time first. That's really at the employee's discretion. So I've been talking for a while. I'm just going to pause really quick to see, Chad, if we want to be able to take any questions right now or if we want to continue to move forward with the slides.
Well, we do have a few questions, so I'll read them off for you, Gina.
Okay.
There's a concern about number of employees. The example given is we have about 25 employees at a time, but unemployment reports indicate 25 to 37 each quarter. We have about 18 full-time employee equivalent. Do I have to participate as a large employer?
Okay, so let's take the first part of that question first, and then I might have you repeat the second part of that. So really what we're concerned about is who is on your payroll and where are the payroll deductions. So for example, if you have 30 employees today and you do have some temporary staff or those that come in and out of your organization, what we're really going to look for, I'm trying to see what slide I want to do, is this $3,900 in wages. Oh, sorry. Is this $3,900 in wages. So if someone is going to be on staff and potentially make that $3,900 within 4 quarters, the state is going to determine that those people might be eligible and those deductions will start coming out right away. So if there's more clarification on that, we'll address that at the end of the call. And then Chad, what was the second part of the question?
About do I have to participate as a large employer? I can read, do
Yeah,
you want me to read the whole thing or?
well, if you have to, so you're going to be determined based on the amount of people on payroll that go over this $3,900. So if you have 31 or more, then you would be considered a large employer. If you're at that 30 or under, then you would be the small employer. And that's how you're going to be receiving the deductions through your unemployment account. So through your unemployment account, it will basically tell you what your deductions are going to be based on. I think we had reporting due last October. I think that's what's going to happen in regards to the deductions. And if you're a small employer or a large employer, they're going to use those payroll numbers.
And then I think Kathy did an update comment on that. Kathy, do you just want to say your question?
Yeah, so we don't have more than 30 employees at a time, but I read that it was based on quarterly unemployment reports where I might have 35 at a given time because three are leaving that quarter and five are leaving, five are coming, so that adds 10 people. So is that really what I have to base it on, assuming they all make over 3,900 a year? Or is there a way to like contest that or say, I don't have 37 employees at a time?
Yeah, Kathy, I think I'm going to be the bearer of bad news on this one because they are going to really go from the quarterly reporting that you're providing. So if there's overlap of employees, I think they might throw you into that large employer bucket. I would specifically for that question, send an email to the state of Minnesota confirming because there's so much that's not said at this point in regards to specific details. That might be a question I would escalate to the state.
Okay, and
And I
also a part of that is like sometimes that happens because employees don't work out, so they're only there for a month. So they clearly wouldn't have made $3,900 in the year. So
Right.
how do I communicate that to them?
That's going to be a good question. I think it's going to be based on the reporting that's done through unemployment. But again, if you have employees that come on and don't last, they still need to pay in to the program. So the deductions will still be made. I think the clarification is the first and foremost that you need to get is, are you going to be considered a large employer or a small employer? Because that's going to impact the deductions and the setup that you have for your employees. So if they consider you a large employer, you would go with that 0.44 and 0.44 for you as an employer, and then for them as the employee. And they're going to start paying into it because even if they go to another employer, they still would then be eligible as well. So all of these deductions are going to start January 1st. And then it's going to be the state to determine whether or not they're able to take the leave or not. But the deductions for sure are going to start coming out January 1st for everyone.
Yeah, okay.
Yeah,
Kathy,
I
since you
know.
got the floor, do you want to just mention your other questions you have in the chat?
Yeah, are reported tips included in the benefit determination? Like, will they pay this on their tips and will they get paid for tips?
Yeah, so that's been a really big one. I have that in my FAQ that will live out on my website as well. So this is a little bit different because it's a deduction and not considered taxable income. The minimum wage and the tips will be added together for their full payroll dollar amount. So they will have to pay the 0.22 or 0.44% deduction on their minimum wage and tips. It's their gross
And
income.
will they be paid accordingly if they have leave?
I believe so.
Okay.
Yes.
And
Mhm.
then do you also take out that percentage on PTO? Like if you have sick, safe and leave time and people have sick time, do they also pay the 0.44 on that?
That's a good question. I'm going to have to get back to you
Oh.
on that. I believe that any sort of time where they're receiving payroll, whether it's PTO or unsafe sick time, if they're receiving compensation, they'll have the payroll deduction.
I have an answer if you want me to jump in on
Yeah,
that one.
please.
The answer is yes, because it's gross wages.
Okay.
So like even when you pay like holiday pay, if it's showing up in gross wages in the unemployment report, which it is, all of those special things are included.
Okay, thank you.
Yeah, thanks, Kara. I appreciate it. Do we have any other questions, Chad, that we wanted to go through right now?
Well, Kara, you also had a comment about earn sick and safe. Did you want to bring that up or do you feel that already kind of got discussed?
No, that wasn't discussed. You mentioned on intermittent leave, the employer can determine the time frame, 1 hour, 4 hours a day. But would that have to match what we've already determined? Most employers have already determined how they're going to do ESST in the smallest increment
Yeah, so
or not.
it's really good clarification because earned safe and sick time and paid family medical leave, my understanding is that they're two different laws and at this point, two different qualifications. So the state has said no less than 1 calendar day, but that employers can determine if that doesn't work for them, that they can go down to do hourly increments to match earned safe and sick time.
So it's truly optional. We don't have to follow what we've already decided in one law. They can be different. Okay.
That's my understanding.
Yeah.
Is that
Okay.
they can actually determine if they only want to do 1 calendar day.
Excellent. Thanks.
Yeah, not a problem. My hope is that they would align more. But I don't believe that they've officially fully aligned at this point. Yeah, great question.
Those are all the questions for now, Gina, so
Okay,
you can
great. Let's
continue.
keep going then. Fabulous. So the next piece that I really wanted to cover is the private plan option. At this time, all of the private plan options have closed in regards to submitting applications and being approved for January 1st. However, I would encourage everyone on this call to continue to either reach out to me or have conversations in regards to connecting with benefit brokers to have additional conversations around private plan options, because I do believe that private plan options will have some benefits, and we'll talk about those in a minute. Because if you go to a private plan option, you will be able to move on a quarterly basis. So the private plan options will do applications and do submitting approvals for April 1st, opt out of the state. So as long as there is an equivalent plan to what the state is offering, you can go out to a private plan. There's a private option called Secure Point, as well as other organizations that you might have heard of like MetLife, Unum, Guardian. There's numerous organizations that are doing private plan equivalent options. Depending on how many employees you have, will determine who will underwrite your coverage for private plan options. This one organization will do any one that's 10 employees or less, and they'll also provide you with a quote that is hopefully comparable to the state. I've seen rates as low as 0.56, and then I have seen some rates come back from private plans that are higher than the state, and that's typically if you have a large portion of women that are at your organization and women that are childbearing ages. Tend to have higher rates because, again, we're underwriting based on the risk within the organization. The employee leave controls and continues to control the total time off request. This is a hard sentence. However, I want to explain it verbally, is that if you are part of the state plan and someone goes out on a leave, that leave will continue to control their leave if you go to a private plan option. So you might have to administer through a state plan if someone takes a leave, as well as moving to the private plan option. And then if you are on a private plan and get switched back to the state, that person that's out on the private plan option will continue to leverage that leave. And then all of your new employees will then be going with the state plan. So it's just saying that wherever the person takes leave, it'll be continued to be controlled by that leave. The other piece is that if a plan is terminated, the private plan, deed and the state of Minnesota can require that within a 10-day notice for you to switch back over to the state plan. There's also some questions and concerns about how long that you would have to stay with the state plan, and if it's a 3-year lock-in to stay with the state. So I'm going to have a specific FAQ on my website that goes through some of those questions and concerns about when you can opt out with the state and how long, if you go back to the state, that you do have to remain with them. But again, if you fail to pay the benefits or the premiums promptly, or if you're unable to submit reporting on time, the state could mandate you to go back with the state plan if you've opted out for a private plan. So any questions about private plans? I think I saw a couple come through, Chad.
Yeah, there was a couple questions. One is, what is that website again for the company that will quote for employers under 10 employees?
You know what? So you do have to go through a benefits broker. So if you need a recommendation to a benefits broker, we can get you a couple of options, Chad, to share with your partners. And then you might have some other connections to benefit brokers as well.
Okay, and then the other question was, what is the best email to send questions to the state regarding the plan?
Yeah, you know what? Let me get that to you in the chat at the end of the presentation. I think that it's also in the presentation here.
Okay.
Great. Wonderful. If everyone could go ahead and mute their line then, and we'll keep moving forward. This is just a quick slide to give you some understanding in regards to the benefits of working with the state or a private plan, or maybe some concerns. One of the pieces that I do want to mention is the cost for the state plan could go up by at least 50% without additional state legislature approval. So today the rate's 0.88. It could go up to 1.25% as of 2027. So that's why I would encourage people to look at private plan options and to go through the underwriting process as quickly as possible. It's great to secure and lock in a rate as quickly as possible so that if you do move as a 4-1, you can get that rate, because then you won't necessarily have anyone that's maybe gone out with your company on paid family medical leave or has gone to the state, and you can secure hopefully a lower rate before anyone goes out. Also, cost changes are going to be statewide with the state plan, but the private plan could be based on individual experience or the risk that that organization has taken on with the private plan carrier. Also, there could be lag time with claim payment. I want to be really honest that we're the 14th state that's implemented this plan. However, we're doing it after COVID. A lot of people have put this in prior to COVID, so there might be some nuances. This plan is not funded today. The funding is going to come when all of the employers pay in April. So I'm not sure where the funding is coming from January to April. It's really unclear to me. And the state of Oregon and Colorado, even though they were funded programs, they had delays of payments of up to 180 days. So I share that not to cause additional concern. However, I want to be really transparent with the fact that there could be lag times. So someone could go out on leave, not be compensated, and they might come to you trying to gain understanding. And that could create some consternation between employer and employees, because they really do have to continue to work with the state. Also, there's really no experience to administer leave of absence claims with the state. Private plan carriers do this day in and day out, and they have previous experience. And again, they might be calling into a call center versus one point in contact who knows your organization and knows what's happening with your employees. So just some nuances of the state versus private. Any questions that have come up, Chad, in the chat in regards to state versus private plans?
Not questions, but the email address, Kara put that in there, paidleave@state.mn.us. And she did mention that the state has set aside money to pre-fund the program.
Oh, good. Well, that's amazing. I don't know how much that is, but I'm excited that hopefully we won't have lag times for payments. I think that's going to be crucial. The next thing is just notice and employee poster requirements. Employers need to provide at least 30 days notice before collecting premiums. So again, that's going to be 12/1, or for anyone hired after the new year to be able to provide that as people are onboarded. Notification can be provided either written or electronic, and needs to be in the employee's primary language and have acknowledgement of receipt. So I'll send out the English one to Chad so that he can provide that out to the chamber. And then there's also Somali, Spanish, and Hmong that are out on the state website. And employees also must display a poster at their place of business in a conspicuous place like a break room or a communal space. There is also potentially some taxation impacts depending on how paid family medical leave is organized and distributed through your company. So this is just a really quick overview. Again, I would defer to a tax professional in regards to, is this fully employer funded? Is it partially employee funded? Is there any impacts on Social Security and Medicare? And then who's providing the Form W-2 to your organization? So again, this is just anecdotal, high level, and again, please speak to a tax provider. The other thing is there could be other costs included. It's not just necessarily the payroll deductions. However, there could be administration costs to leaves, communications, policy updates. There could be higher frequency of leaves or integration with other state and federal leaves, like I did the grounding at the beginning of our call. There could be longer duration of job protected leave, so it could be up to 20 weeks. What I guide employers to do is, what about supplemental staff? I have a client today who is bringing on supplemental team members that could be on call in case anyone needs to take time out. So they're doing some training in November and December to make sure that they don't have a gap within their employee population, and how to make sure that the product still is able to be delivered. Again, we cannot require the use of other time off, whether it's earned safe and sick time, PTO. Again, we could have an effect on the quality, quantity, or productivity implications. And then, again, it could be an increased opportunity for employee relations issues. There's a lot of feelings all over the board in regards to, are we happy that this is a state law? Are we not happy? What's the impact of being mandated versus not mandated? Lots of feelings for everyone involved. But then also, we do need to make sure that we're keeping appropriate records, that we're doing training, reporting, and just, again, really looking at the staffing implications. Some big key dates and deadlines. So November 10th was the deadline to opt out of the state plan. We are now past that. But again, we'll have quarterly opportunities to opt out of the state plan. And I would encourage people to have conversations with benefit brokers to look at those private plan options. December 1st, again, all employers must notify employees about the paid leave benefits. And then January 1st, premium deductions begin and employees become eligible to take leave and to request the leave. And then April 30th, first quarter premiums are due no later than the state. One other piece that I haven't put in here is that if you haven't gone out to your unemployment account and designated a plan administrator, that is also something that you would do, because it does take 24 hours for that plan administrator to be approved before you can make any sort of premium contributions or opt out of the state plan. Here are some additional websites. So there is an FAQ on the website for the state government program. Again, how to register for an unemployment account if you have not done that. You can also sign up for paid leave updates. And then again, I have my email as well as email for Annie DeBose. I think I have this on my last slide as well. For questions, Annie is one of my trusted small business lawyers. So if you do have any questions about and want legal advice, she is there to help you with that. I can definitely help you with any sort of policy updates, as well as employee handbook updates. I can work with organizations on an hourly basis. However, I do love to really partner with small businesses and help with overall transformation. So I have different levels of subscription programs, and then I also work on retainer from more of a fractional HR perspective. But I'm more than happy to give anyone on this call a complimentary conversation to help them out with any other questions or specific nuances that might be with your organization. So you can always email me at gina@vividjoyhr.com. And then I'm out on LinkedIn, Vivid Joy HR as well, providing different updates and information, not only about PFML, but a lot of HR sort of culture and compliance conversations. So my QR code's here on the screen. If you want to connect in with me on LinkedIn, would be more than happy to do that. And then we can take some time for some more questions. So Chad, thank you so much for letting me join you today with the chamber. I appreciate you.
Yeah, absolutely. Thank you so much, Gina. This is really going to be helpful. And like we said, the recording is going to be sent out. You have a chance to review that too. And there will be some follow-up information that Gina can provide us. One question was about the email address for the state, but that is just that paidleave@state.mn.us, I believe. I don't know if there's any other ones that would make sense from the state. And then Kara, you wrote a very long thing. Do you want to just say it?
It's
And then
not
Chad,
so long, but I just wanted to tell people, well, the slide says, and it's true, we can't require employees or force them to use the PTO and their ESST. As a practical matter, most employees are going to want to use that during that 7-day or 5 to 7 day qualifying period. And we certainly can allow them to use it, of course. But in addition, some attorneys have said you can kind of get around this requirement by telling employees, we will apply your accrued PTO or ESST during any unpaid time and make it an opt-out. meaning they say, go ahead and tell them you're going to apply the time unless they want to opt out of it and not use the time. And the nit in that would be if they don't use PTO or ESST, it's not covered by that. And it may or may not end up getting approved and qualified by PFML. So then it may not even be job protected if that ends up happening. But the point is, you can actually say you're going to apply it, but give them an opt-out option so that they could not apply it, and then it's not a requirement. And then the last thing I wrote in there just is you can also choose to allow top off and to make people whole in their income while they're on PFML. But I think that's a payroll nightmare in the first year while we're all figuring this all out. And so just know you can do that, and employees may request it because I've already had employees who read things online and are asking about that. It's an option, but talk to your lawyers and CPAs and payroll and HR people to help you with that.
That's great. Thank you so much, Kara.
And it looked like there was still some confusion on if that paid leave was a website or an email address, but Kathy, it sounds like you found the proper email address.
Yeah, if you go on the website and you go down to the contact us, there's an email.
Okay. Gina, one question I had. So you said that we're the 17th state to enact something similar to this. I know that every state has their own nuances, they're not all the same, but have we learned any lessons from the first 16? Is there anything in particular that people are saying this was an unforeseen challenge that we had when we got it going, or anything else that we can learn?
That's a really good question. We're modeling our program after the state of Massachusetts. So I feel like a lot of employers are really worried that there's going to be a mass exodus of employees taking this leave as of January. And what I will tell you is that a lot of people are living paycheck to paycheck. So even though they're able to take leave, I still think that they want to be able to have their full compensation. So if they don't have a lot of ESST, if they don't have a lot of PTO, if they've leveraged what buckets of time they might have off, I don't think you're going to see a mass exodus. One of the pieces actually that the state demographer in Minnesota has said, because of all of the other states that have taken leave, is that maybe up to 30% of employees will be gone during this period of time for the initial, I would say, first 1 or 2 quarters, and then we'll start to see it trail off. But that's really, if I have 100 employees, it could be 1 or 2 employees that might be gone from my organization. So what I would just really encourage people to have conversations about is to tell their employees that we care about them, right? And if they do have any exigencies outside, maybe we don't know about the person whose mother is diagnosed with cancer. So it's a really great time to express empathy, to say, hey, we want to keep our organization moving forward and we care about you. This is a new law that's coming. And if you have any special needs, how can we work with you and partner with you? I have one guy that was going to be out, he's commissioned, and his mom is literally, in the process actively of dying from cancer. And he wants to take a week on and then work a week, and take a week off and then work a week. So I think it's just really about knowing that, up to 30% of our employees can be out for the first 1 to 2 quarters.
Okay. Lynn, you have a question?
Thanks. Yeah. For us, we've had a self-funded pseudo of a short-term disability for medical, and many, we've given it for, obviously, for maternity and leaves, like we're just talking about and stuff. And so for our people, it's a loss, because the state is not fully funded like we are. So we are working to put everything in place to be able to true it up. So we will use our self-funded to true it up. They'll still pay their 50%, we'll pay 50%, but we're going to take what we have given as a benefit and still give it going forward to true it up for people. Because like you said, that paycheck to paycheck is hard for people. So we may have more people wanting it as a result, but it's okay. We still want to take care of people.
Oh, I love that. And I think that you're for sure an employer of choice because I've had other organizations that want to have supplemental benefits or have had supplemental benefits and want to true it up as well. There is an option just in case you're not aware and the opt out from the state has already passed, but you could still opt out in the future, depending on how complicated it is to do the true up process in and of itself. But you can do a self-funded option and opt out to do self-funded. You just need a bond as well. So hopefully you're working with the broker and legal team or other HR folks, or you can call on me too to help you with those policies and procedures.
Cool, thank you.
Yeah, love it. Great.
Question in the chat, for a qualified event, will Minnesota paid leave and FMLA run concurrently or are they stackable?
So they will run concurrent. If you have more than 50 employees in a 75-mile radius, you would have FMLA that is already running today if someone's out on leave, but then paid family medical leave will stack on top of that. One of the challenges is if they expire FMLA and they haven't expired paid family medical leave, you would still need to allow paid family medical leave to expire in order to have job protection because both offer job protection, but now they're going to be running on two different cycles, even though technically you could stack them. So I just want to be really clear that yes, they stack, but they're going to potentially have two different time frames.
Thank you. Another question, I was talking to somebody who had, they talked to somebody who worked at a larger accounting firm. And, a lot of us, when we're hearing this news, we're nervous, we're anxious, we don't know what it's going to be like, we're concerned about the extra cost. But this person at this larger accounting firm actually was happy about this new policy. Can you talk about why an employer would be happy about this policy?
Oh, for sure. I know a couple of employers that actually went to the Capitol Hill to say this is a really important law because they did have a small company and they had someone that needed to be paid for maternity leave because they were living paycheck to paycheck and were not able to support the cost of this new baby coming into their life. So instead of one employer paying for the whole cost of maternity leave for their employee, now we get to really, I would say, be more equitable and have everyone pay in a very small portion so that those who really do need the benefit can take the benefit. So I think that's where an employer would be happy is that they actually get to distribute the cost. Let's just take, was it Lynn that you just said that you already provide those supplemental benefits? Now actually they get to reduce their costs that they've been paying for such a potentially long period of time. So it's really more equitable for everyone to pay in a little bit rather than certain small employers having to fit the bill all themselves or to not be able to provide the benefit. So I think you're going to have, again, there's going to be people on each side of the spectrum, but those are the happy employers that say, wow, we can actually do more for our employees now. Good question.
Does anybody else have any final questions? All right.
Right.
Well,
Well,
seeing none.
I was going to say, I will put my email in the chat as well. So again, if there's any additional questions, or if you want to just spend a half an hour of time with me on a call talking through, then I'd be more than happy to do that.
Great. Thank you, Gina, and everybody else. We will be putting this out on a recording soon. So thank you for attending.
Have a great day, everyone.
Bye.
Bye.